Well, majority of states now have some kind of carry law, and Florida being the latest to have permitless carry. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And, of course, we've been tracking the latest in litigation against Illinois' gun ban, but there's tons of other gun-related issues across the country and here in Illinois that obviously need attention, as a lot of gun owners are weeding through all of the various ins and outs of how the court systems work and how governments try to pass legislation that people see as an infringement on their rights, including the Second Amendment right to keep and bear arms shall not be infringed. So lawsuits abound, and we'll talk about an Illinois case that we touched on a bit yesterday. But I wanted to get to a few headlines here. As you see on social media, there's various maps that are being produced that show kind of the timeline of states being able to conceal carry. And a GIF that kind of just cycles through. But the headline out of Florida is Florida Governor Ron DeSantis. He signed legislation the Florida legislature passed, allowing people to carry a concealed weapon without a permit. And obviously, the advocates of the Second Amendment say that this only makes sense because the Second Amendment says shall not be infringed, the right to keep and bear arms. But others pushing back saying it's dangerous. And you've got both groups obviously pretty vocal in their positions. But we've got another case here that I just got alerted from a news app. Minnesota. Here's the headline from ABC. Minnesota gun ruling is latest citing Supreme Court decision. A federal court ruling that a Minnesota law prohibiting 18 to 20-year-olds from obtaining permits to carry handguns in public is unconstitutional and remained on hold while the state pursues a potential appeal. So interesting to see that case as well, citing previous precedents set by the U.S. Supreme Court when it comes to the Bruin decision. So these are two different issues. One in Florida, the state legislature passing permitless carry. And in Minnesota, a judge having to step in and, in a way, motion towards issuing rights in a way, though a lot of people say government doesn't give you your rights. The Second Amendment has the right, and it shouldn't be based on age, which in Minnesota, apparently they were trying to limit that on age from 18 to 20, not allowing those individuals to get permits to carry. In Illinois, we have a permit. It's called the FOID card, the Firearm Owner Identification card, and it's been around since the 60s. It's gone through different iterations. We got concealed carry, in like 2013 or so, in the state of Illinois with a concealed carry permit. But the FOID card, there's some interesting things, of course, with how that has played out, even in the courts. I talked with Thomas Maag. He is the attorney that is suing in the Southern District against Illinois' gun ban, one of four plaintiffs' groups. But he also has other cases, including one case dealing with the FOID card that was decided by a county judge, and an appeal is possible. Here he is talking about a case out of Madison County concerning whether or not somebody that is arrested should have their FOID card taken away. Here's Thomas Maag laying out the details of that case.
Case originated because Mr. Davis and his son over a 4th of July holiday a few years ago, fired a couple of rounds into the ground at their home, which they shouldn't have done, but, I mean, it's the 4th of July. It's technically a petty misdemeanor. I get it. Well, of course, fireworks are generally illegal like everything else fun in this state. And the police come over the fence and ask him whether they'd fired a couple of shots off on the ground. And he said, yeah, we did. It's the 4th of July. Well, at that point, the police decided that he was shooting into the air, which is, in the police's view, a reckless discharge of a firearm, which the police officer said was a felony, which the charge is a felony. And so they arrest Mr. Davis and his son on the 4th of July, and charge him with reckless discharge of a firearm. Long story short, it gets reduced back down to a misdemeanor, which is where it probably should have been in the first place. Mr. Davis gets his gun back, but it takes several months for Mr. Davis and his son to each get their FOID cards back, because in Illinois, when you're charged with a felony, Illinois suspends your FOID card. Doesn't matter what the proof is, doesn't matter what the charge is other than a felony. Any felony results in the suspension of a FOID card. Well, that's just not right. In this country, we are innocent until proven guilty. And I get that there's a lot of people who are arrested and charged with felonies that probably are dangerous, but they're dangerous because they're dangerous, not because they're charged with felonies. So we filed this lawsuit, and long story short, we litigated against the state for several years, went through several judges, several judicial retirements. But Judge Foster, again out of the Madison County court here, about 3 weeks ago granted our motion for summary judgment on a permitted injunction, finding that under the Bruin test, and I think he's completely right, the Second Amendment cannot be suspended merely because somebody has made an allegation of a criminal offense. That, of course, wouldn't stop a court from entering as a bond condition in an appropriate case. But for instance, it's a felony to write a $300 check that bounces. I've handled a couple of those for clients, and in 2 out of 3 of those occasions, that was a bank error. So for a bank error, the state would suspend a person's FOID card. And again, that's just not right. So as of a few weeks ago, the state has now been enjoined from suspending Firearm Owner's ID cards in Illinois for persons who are merely charged as opposed to being convicted of felony charges.
Again, sharing some of the conversation I had with Thomas Maag yesterday, the attorney who brought this case down in Madison County, and several weeks ago a judge did issue that ruling that enjoins the state from limiting individuals' FOID cards if they are charged with something, not convicted, charged with something. Here he is explaining what that ruling ultimately means.
As of right now, the law of the state of Illinois, and ISP has to comport with it. I would be surprised if the state of Illinois does not attempt an appeal. I think the odds of an appeal by the state are roughly 99%. They would appeal if they chose to appeal directly to the Illinois Supreme Court, which it would be a mandatory appeal for the Supreme Court, Illinois Supreme Court, to take the case. On the other hand, if I were the state, I would just let it lie. But they didn't ask my opinion.
Again, Thomas Maag, the attorney who brought this case, and ultimately you do have the state, according to the docket in this case, filing and getting a motion granted to delay their response for possible appeal. They now have until April 12th to file that possible appeal. Maag talked about the taxpayer cost here because he's an attorney. He's representing private clients who feel that their rights have been infringed. He's got to have his lawyer fees handled somehow.
Notices of appeal are generally due within 30 days of final judgment. Final judgment technically has not been entered yet because there's the issue of my attorney's fees under 42 U.S.C. Section 1988. Once the court rules on my attorney fee petition under the Civil Rights Act, at that point the state has 30 days from the ruling on that fee petition to file its appeal.
And how much would that ultimately cost taxpayers?
If they simply paid the current fee petition and dropped it, I think I'm asking for a little less than $30,000. If it were to go up to the state Supreme Court, the last fee bill I did for an Illinois Supreme Court appeal, which was in a pension case when Quinn was governor, I think we billed $400,000.
So just an idea of how much such a case could ultimately cost, just in this particular issue, going to the Illinois Supreme Court. Again, that's Thomas Maag, an attorney who brought that case challenging the state police suspending FOID cards for people who were charged, not convicted of crimes. And state police, as of right now, enjoined from suspending FOID cards. Interesting turn of events. We'll track that case as well here. I'm Greg Bishop with Springfield's Morning